Welcome to Canadian Justice. I'm Christine Van Gyn, and today's part 2 of our discussion about a case that was just decided by the BC Court of Appeal. The long-awaited appeal in a case brought by a group of surgical clinics and patients who are challenging the government monopoly healthcare system for failing patients and leaving them on seemingly endless wait lists, but simultaneously preventing them from accessing healthcare outside of that government system. This is a case that my organization, the Canadian Constitution Foundation, has been supporting, so I'm invested in the outcome of the case. Today we'll be focusing on the legal reasoning from the decision in Cambie Surgeries and BC, and what next steps in the case are going to be. We're joined today by Joanna Baron, the Executive Director of the Canadian Constitution Foundation, which is the charity I work for. And we're also joined by Craig Dennis, the lawyer representing a group of patients who intervened in the Cambie Appeal. Thank you both so much for joining me today. Now, we've already just gone over the facts of the case in part 1 of this episode, but briefly, let's remind our viewers who might not have caught that episode. Joanna, what can you tell us about the background of this case and why it was brought?
Yeah, so the case goes back more than 10 years, and it was brought by Cambie Surgery Centre as well as a group of patient plaintiffs, all of whom had the common quality that they were suffering serious ailments from lengthy waits on wait lists, ranging from a child who developed a permanent curvature in his spine and is now permanently paralyzed, a high school student who was unable to receive a soccer scholarship because she didn't get knee surgery in time, a woman who her doctor testified would have died if she hadn't gone outside the public system to be screened for colon cancer. So those patients, as well as Dr. Brian Day and Cambie Surgery Centre, brought this charter challenge, which is now one of the largest charter challenges in Canadian history, seeking to strike down certain provisions of the Medicare Protection Act.
Craig, anything briefly to add about the background of the case?
But just the legal context, there was, of course, a 2005 decision of the Supreme Court of Canada that we may touch on later that made a ruling with respect to a Quebec law that was found to restrict access to healthcare. And so that sort of set the backdrop legally for this challenge in British Columbia.
Yeah, that's a case called Shauli, which we'll discuss later about why that isn't the governing case. Well, perhaps it should be, but why it wasn't here. So, Craig, you're representing a patient coalition who intervened in this case. What can you tell me about that coalition and the perspective of those patients in the Cambie case?
Yeah, so I was fortunate to represent a group of concerned British Columbians who had experience with the public healthcare system. The circumstances and conditions varied among them, but they shared an interest in seeing better access to healthcare. And it's important to note that there were patient interveners on the other side of the case as well. It's an important public issue. And certainly what we sought to do was to bring to the court that very patient-centered perspective. There's a lot of emphasis on access, timely access, equitable access, and the perspective that we put forward is that you can't have equitable access without access at all. And that really was sort of the patient-forward perspective we were putting forward.
And Craig, what can you tell me about what the rights engaged were in this case? What were the patients, not just your patients, but the patients in the underlying litigation, what rights did they say are violated by these laws that were being challenged?
As the case was presented to the BC Court of Appeal, the right in issue was Section 7 of the Canadian Charter of Rights, and the challenge was to specific provisions of British Columbia's Medicare Protection Act, as you said at the outset, that had the effect of restricting access to healthcare.
Craig, sorry to interrupt, just to be clear, Section 7 of the Charter governs the right or guarantees the right to life, liberty, and security of person, right?
Exactly. And there's two prongs to Section 7. So Section 7 says that we're guaranteed the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. And of course, that concept of the principles of fundamental justice played a central role in the court's decision. And the way that the courts approach that is two prongs. So first of all, has there been a deprivation of either life, liberty, or security of the person? And then second, if so, was that deprivation in accordance with what we call the principles of fundamental justice? And in order to establish a violation of Section 7, the claimant has to satisfy both of those prongs. There is a deprivation first, and second, the deprivation did not accord with the principles of fundamental justice. And as we'll
Right.
talk about,
Yeah, and we'll talk about what because that term fundamental justice, principles of fundamental justice, has a specific meaning in law, which the court gets into. We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing a recent BC Court of Appeal decision in Cambie Surgeries and British Columbia, a case that my organization is invested in. Now, Joanna, today we're focusing on the legal reasoning in the decision in the Cambie Appeal. So let's start with the majority. Can you tell me what the majority in the Court of Appeal found about whether patients' Section 7 right to life and security of person was being violated by this prohibition on private insurance or dual practice, the restriction on private healthcare in BC?
Yeah, so as Craig just mentioned, there are two prongs to a Section 7 violation. So the majority did find that the rights to life and security of the person were violated, but they also found that these violations occurred in accordance with the principles of fundamental justice. So in the result, there was no Section 7 violation. And in that query around fundamental justice, we're looking at whether the law is arbitrary, overbroad, or grossly disproportionate.
So, Joanna, how significant is it that the court found that the right to life here was violated, that these laws could result in patients actually dying? And is that finding different by the Court of Appeal? Is that different from the trial decision?
So first of all, it is different from the trial decision. The trial judge found, the BC Supreme Court found that there was no evidence that lengthy waits for care had led to any identifiable specific individual's death. So first of all, I think just on its face, the fact that the Court of Appeal disagreed with that finding, disagreed that there was no violation of the right to life, of course, is hugely significant. And the reasoning was that it's not necessary to prove that a specific person who's before the court experienced the risk of death, but they found that on the record, there was lots of expert evidence that could identify what they call a class of persons for whom lengthy wait times increase the risk of death, which I think just accords with our common sense. We know that the longer you wait for certain types of conditions, the more you're at risk of adverse outcomes, including death.
So the Court of Appeal found that these laws could infringe the right to life and security of person, but as Craig mentioned, they found that this was consistent with the principles of fundamental justice. So, Craig, for our viewers who may not be familiar with this term, what does that mean in law? What are the principles of fundamental justice, and how do they interact with our guaranteed right to life and security of person?
As Joanna mentioned, in this context, there really are three principles that the courts assess and analyze, and that is whether the law is arbitrary, whether it's overbroad, and whether it's grossly disproportionate. And so as Section 7 has been interpreted by the courts, Section 7 tolerates deprivations of life, liberty, or security of the person, provided that the law that brings about that deprivation is not either arbitrary, overbroad, or grossly disproportionate. And so in this particular case, as Joanna explained, while the court found deprivations of life and security of the person, the court concluded that the laws were not either arbitrary, overbroad, or grossly disproportionate. That's the majority view in the Court of Appeal.
Now, Joanna, it does seem counterintuitive that a government policy could actually violate the right to life, but still be consistent with the principles of fundamental justice. Basically, the court is saying, yes, we acknowledge that this law could kill people. So how could that be fundamentally just? This is confusing for a lot of people.
Yeah, so the principles of fundamental justice analysis, I first of all agree that there's a lot of dissonance here and there's a lot of apparent dissonance, and we'll get into the concurring decision that makes that a bit more explicit. But essentially what the court does is they look at the law's purpose to look at this principles of fundamental justice analysis, and they end up saying that its purpose itself is to govern all healthcare in British Columbia, not just in the public care system, but all delivered healthcare. And if you look at it from that perspective, then it's not arbitrary or overbroad. But they're essentially saying that in this finding, some laws are rightly and in accordance with the principles of fundamental justice sacrificed to some type of greater good that the law is aimed at.
Craig, we've only got about 30 seconds, but your perspective on that.
Yeah, I think it really is a question of the connection and the match between the law's purpose and its effects. And in this particular case, the majority felt that the connection or the match between the purpose and effects were not sufficiently out of line to strike down the law under Section 7.
Now, there was a concurring decision in this case. We've got to go to commercial break now, but a concurrence is the judge found the same thing, had the same outcome, but for different reasons. And those reasons in a concurrence are really fascinating and shed a lot of light onto some of these issues. So we've got to go to break, but we will discuss that concurrence when we come back. Welcome back to Canadian Justice, where we're discussing a BC Court of Appeal decision that challenged the government monopoly on healthcare in that province. We're discussing the legal reasoning of the case with Joanna Baron and Craig Dennis. So, Joanna, the majority in this case found that the law preventing patients from buying private insurance and the law that prevented physicians from working in both the public and private systems violated the rights to life and security of person for those patients. The majority found it was consistent with the principles of fundamental justice, but there was also another decision, what we call a concurrence. So, Joanna, what can you tell me about what that concurrence found?
So the concurrence found that there was a Section 7 violation, full stop, not in accordance with the principles of fundamental justice. However, the result ended up being the same, meaning that the law was saved and not found to be unconstitutional, the Medicare Protection Act provisions, because the concurring judge found that they were justified under Section 1, which asks whether the violation can be justified in a free and democratic society, which is quite extraordinary.
Craig, anything to add about that concurrence?
Well, just that it really highlights one of the central features of the case, the exercise in justifying the deprivation of life and security of the person. Analytically, where does that justification exercise play out? That's a really important, from a jurisprudential standpoint, a really important part of the case. The difference between the majority who did that exercise within Section 7 and the concurring judgment who approached it as a government burden justification under Section 1.
So Section 1, our viewers might be familiar with that. That's the justified limits part of our charter. It asks if a limit to our right is justified in a free and democratic society. Briefly, Joanna, can you explain how that section of the charter works, what the court asks when that's being applied?
Yeah, so under Section 1, explicitly the judge is invited to weigh the effect of a rights infringement, which has been previously found to get to Section 1, with other legislative objectives. So they are meant to look at broader public aims, which they're not meant to do in something like Section 7, which I would say arguably they did, the majority did in this case. And it has been criticized for inviting this sort of non-judicial policymaking function, finding proportionality between rights and objectives.
Joanna, how unusual is it for there to be a finding that a right to life was violated, but that violation is justified by Section 1, which is what the concurrence here found? How unusual is that?
It's extremely unusual from the outset, from the early days, post-charter adoption in an early case called BC Motor Vehicle Act. Lemaire said that it would be extraordinarily rare that a Section 7 violation would be saved under Section 1. These are serious violations. And in fact, the only time it has happened in Canada previous to this decision was in a 2015 Ontario Court of Appeal decision called Michaud, which had to do with highway speed regulations. And that case was denied leave by the Supreme Court of Canada. So we haven't sort of had the Supreme Court's view on whether that was correct or not.
Right. Craig, there were these two decisions, the majority and the concurrence, which found pretty different things, although the result was the same, the reasoning was really different. So what might that mean for an appeal to the Supreme Court, that there were these two different opinions?
I would expect that the fact of these two different opinions, that there was disagreement in the analytical approach, would be a factor favoring the Supreme Court of Canada granting leave to appeal. The Supreme Court of Canada is more likely to grant leave where there is some uncertainty in the law, a suggestion that there's a need for clarity or guidance. And as Joanna said, this idea that Section 1 can be used to save Section 7, although it's been discussed in Supreme Court of Canada cases, including BC Motor Vehicle and more recent cases, they've never been confronted with that question directly. So certainly it would be something you'd think would catch the interest of the Supreme Court of Canada.
Joanna, we've got about a minute left, but a lot of viewers, as we mentioned at the beginning, might be familiar with an older case from the Supreme Court about healthcare that came out of Quebec in 2005, a decision called Shaoli, where in that case, the Supreme Court found that Quebec wait times were violating the fundamental rights of patients and that the restriction on private insurance in that province was unconstitutional. So that case seems pretty similar. Why isn't it the governing precedent? Just about less than a minute.
It's just a simple answer that a plurality of judges, not all of the judges, but a plurality of judges, the tie-breaking vote was Deschamps-Jay, found the violation under the Quebec Charter rather than under the Canadian Charter of Rights and Freedoms. Of course, it was a Quebec case, and so it just immediately doesn't apply under the Canadian Charter. So this case would seem to be similar reasoning, but sort of on a formality, the application is different.
Interesting. So when we've got to go to break, but when we come back, we're going to discuss the potential appeal to the Supreme Court and next steps. Welcome back to Canadian Justice, where we're discussing a recent BC Court of Appeal decision that involved a challenge to the government monopoly in healthcare in that province. Joanna, one of the things that strikes me as really interesting in this case is that there have been a number of recent cases that struck down laws on things like bans on assisted suicide, restrictions on prostitution, and even on the withdrawing of an exemption for supervised drug injection. And those laws were struck down because the court found that the government acts violated Canadian Section 7 rights. So in this case, they found that the laws also violated Section 7 rights, but why would the outcome be any different?
So I think it's an important question to ask, and it's hard to find a principled reason why. I think when you read the decision, particularly the concurring decision, there's a lot of hand-wringing. There's a lot of acknowledgement that this is not a good outcome, that people have died and will continue to die as a result of these laws. And it's very difficult to reconcile with the other Section 7 cases about safe injection sites and medically assisted death. I think one reason, first of all, is that the public healthcare system is Byzantine. It's extremely complex. There's a lot of regulatory things that I think judges are very loath to interfere with. But I would say that if you look at things from a principled point of view, that this should actually be an easier issue for judges to deal with, because things like the prostitution case, medically assisted death, that actually created public obligations on government. Hello?
Hi, yeah, we can still hear you. You're just frozen. Craig,
I think I froze.
Yeah, no, it's okay. Craig, I'll turn to you. What's your view on this issue?
I agree with Joanna that it's a particularly interesting part of the reasoning in the case, and there's certainly aspects of it that are open to debate. For the majority, one of the things that they said in terms of trying to situate this case differently from the ones you mentioned is that in the Court of Appeal's view, the vice in this case, the unacceptable wait times, they said was not a direct, inevitable, or even probable effect of the challenged law. And that is, in their view, it was not the law that directly caused the wait times, but rather government choices around funding against the backdrop of the law. And so they saw that as different from the criminal law prohibitions at issue in the cases that you referred to. As I say, I think that's an interesting area for debate, but that was how the Court of Appeal approached it and differentiated this case from the others.
So, Craig, what happens next? Is there going to be an appeal? And if there is, it would go to the Supreme Court. But how long might that take?
The next step is the Supreme Court of Canada. I can't speak for the plaintiffs or the appellants because I don't act for them, but I've seen publicly indications that they do intend to seek leave to appeal to the Supreme Court of Canada. So it's a two-step process. First, they need leave from the Supreme Court of Canada. If leave is granted, then the appeal proceeds. One would expect a leave decision probably before the end of the year, and if leave is granted, then probably an appeal hearing sometime later in 2023, and after that, a decision who knows when.
Well, I mean, this decision took over a year for the BC Court of Appeal, so the wheels of justice turn slowly.
It's a reflection of the complexity of the issues, for sure.
Joanna, if the patients and clinics win the appeal, what might the implications of the case be for the rest of Canada? As we said, Shaoli only impacted Quebec. Would this be different?
Well, this would only be decided under the Canadian Charter, which applies to all laws in Canada. So certainly there would be some type of consultation with each of the provinces, but each of them have substantially similar law in place as the Medicare Protection Act provision. So if it was deemed unconstitutional at the Supreme Court of Canada, I think it would pretty clearly apply throughout the country, unlike Shaoli.
Well, Joanna Baron, Craig Dennis, I want to thank you both so much for coming on today. This is a case that I care deeply about. Joanna, Craig, I know you do too. We're all involved in some level in this case, so we all have a perspective. But I want to thank you so much for coming on today to share your expertise and your insight and explaining the real complex nuances of this case.
My pleasure. Thank you for having me.
Thank you.
We've heard today about a case that was just decided by the BC Court of Appeal, a case about whether or not patient rights are violated when the government monopoly healthcare system makes them wait too long for surgery and simultaneously bans them from seeking care elsewhere. This is a case that I obviously have my own opinions on, but what do you think? And what do you think of the reasoning in the case that found a government policy that could be killing people is fundamentally just or justified in a free and democratic society? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.